Hey guys, tonight we are going to drift back in time further than usual, to a world lit by fire and governed by faith, fear, and a legal system so strange it feels like a fever dream. Imagine a courtroom, solemn and serious, where a judge in heavy robes listens intently to witness testimony. Now picture the defendant standing in the dock listening to the charges read against them. Murder in the first degree. The only unusual thing? The defendant is a pig. No, you didn't mishear. And yes, you'll probably want to stick to the main roads on this journey. The medieval legal system had some, let's just call them surprising detours. You almost certainly wouldn't survive a minor infraction, let alone a major one. So before you get comfortable, take a moment to like the video and subscribe, but only if you genuinely enjoy what I do here. Let me know where you're listening from and what time it is there. It's always fascinating to see where we all are in the world. Now dim the lights, maybe turn on a fan for that soft background hum, and let's ease into tonight's journey together. The air in the hall is thick, heavy with the scent of damp wool, wet earth, and the faint, ever-present aroma of wood smoke that clings to every surface. You're sitting on a rough-hewn wooden bench, the kind that promises splinters if you shift too suddenly. It's cold, a penetrating chill that seems to rise from the stone floor itself, seeping into your bones. This isn't a grand cathedral of justice with soaring ceilings and ornate carvings. It's a town hall, a functional, multi-purpose space in a small, provincial French village, sometime in the 14th century. Light struggles through a couple of high, narrow windows, illuminating swirling dust motes that dance in the gloom like tiny, aimless spirits. Before you, at a sturdy oak table, sits the magistrate. He's a man of some local importance, evidenced by the slightly better quality of his tunic and the weary authority etched onto his face. He looks tired, as if he's presided over one too many disputes about straying sheep or poorly marked property lines. But today is different. The room is packed. The faces of your neighbors are pinched with a mixture of fear, morbid curiosity, and a kind of grim satisfaction. They crowd the benches and line the walls, their breath misting in the cool air. This isn't just another legal proceeding, it's a spectacle. It's a necessary, terrifying piece of community theater. A bailiff, armed with a stout wooden staff, thumps it on the floor for order. A low murmur ripples through the crowd and then subsides into an expectant silence. All eyes turn towards the defendant's enclosure. You follow their gaze, expecting to see a man in chains, perhaps a sullen-faced farmer or a known village troublemaker. Instead, you see a pig. It's a large sow, broad-backed and bristly. She stands on the dirt-strewn floor of a makeshift pen, occasionally nudging the wooden slats with her snout. She seems entirely unconcerned with the gravity of her situation, more interested in a promising patch of mud than the concept of jurisprudence. This, right here, is the heart of the matter, the core of this bizarre historical detour. For centuries, primarily between the 13th and 18th centuries, secular and religious courts across Europe, especially in France and what is now Switzerland and Germany, prosecuted animals for crimes. This wasn't a joke, a metaphor, or a village pantomime. It was a formal application of the law, complete with judges, lawyers, witnesses, and, most chillingly, executioners. The charge against this particular sow is read aloud in a booming, formal tone. She is accused of having murderously destroyed and disfigured the face of a local infant left unattended in its cradle. A collective shudder runs through the assembled villagers. For them, this isn't an accident. It isn't just a tragic consequence of leaving a baby near a powerful, semi-wild animal. It is a crime. A transgression against the laws of man and the order of God. The pig, in their eyes, acted with a form of malice, a bestial culpability that must be addressed, judged, and punished. You watch the proceedings begin. Witnesses are called. The child's grieving mother gives a tearful, harrowing account. Another villager testifies to having seen the sow near the cottage, its snout stained with blood. The animal itself offers no defense, naturally, just the occasional grunt or squeal. It's a strange and unsettling scene. Historians still argue whether these trials were a genuine, if misguided, attempt to apply justice in a world they believed was teeming with demonic influence, or if they served a more practical social purpose, a way for a community to process trauma and restore a sense of cosmic order after a horrific event. By putting the animal on trial, they were transforming a chaotic, meaningless tragedy into a structured narrative of crime and punishment. As you sit there, you learn a fascinating detail from the whispers of the person next to you. While awaiting this trial, the sow was held in the local jail, in a cell, just like a human prisoner. The town's official records will later show an expense for her food and board, paid for from the public purse. The law, in its majestic and terrifying absurdity, demanded that the accused be treated with the proper procedure, regardless of species. She was a defendant before the court, and so she was afforded a cell and a meal, right up until the moment the court decided to hang her. The whole thing feels like a play, where one of the actors hasn't learned its lines and is also, a pig. You're watching the slow, methodical gears of justice turn, grinding towards a verdict that feels both insane and, in this chilly, dark room, completely inevitable. The magistrate adjusts himself at his table, the wood groaning in protest. He is the face of secular law, the temporal power of the local baron or duke, vested in this one man. As you watch him dip a quill into a pot of ink to make a note, you can't help but wonder how this is all possible. How can a legal system, even one from a time so different from your own, accommodate the prosecution of a farm animal? The answer lies in the fact that it wasn't just one system. In the medieval world, justice flowed through two distinct, parallel channels. You had the courts of man and you had the courts of God. The grim spectacle you are currently witnessing, the trial of the sow, is a product of the secular court. This was the justice of the local lord, concerned with crimes that had immediate, tangible victims. When a single animal, typically a domestic one, caused harm to a person or property, it was the secular authorities who stepped in. A pig killing a child, a bull goring a farmer, a horse kicking its owner to death, these were treated as homicides. The legal framework that applied to human criminals was, with a few logical tweaks, mapped directly onto the animal. It would be arrested, imprisoned, tried before a magistrate like this one, and if found guilty, sentenced to death. The goal was retribution and the restoration of public safety and order. This court wielded the power of the sword, the gallows, and the stake. But what happened when the culprit wasn't a single identifiable animal, but a legion? What do you do when the criminals are a swarm of locusts devouring a year's harvest, a plague of rats infesting a town's grain stores, or a writhing mass of caterpillars stripping an orchard bare? You can't exactly arrest a million weevils and put them in individual jail cells. For this kind of mass agricultural crime, you turn to the other legal system, the ecclesiastical court, the arm of the church. This is where the entire process elevates from the merely strange to the sublimely surreal. The church's jurisdiction was spiritual. Its power wasn't in hanging and burning, but in damning and excommunicating. When a community was beset by pests, they saw it as a divine punishment for their sins, but also as a criminal act by the creatures themselves. These creatures were, after all, stealing the bounty that God had provided for humanity. So the villagers would appeal to the bishop. The ecclesiastical court would begin with a formal investigation. A priest or a designated official, acting as a combination of detective and biologist, would be dispatched to the afflicted fields. He would observe the infestation, take note of the damage, and perhaps even collect a few specimens as evidence. Then a formal complaint would be lodged. And this is the truly wonderful part. The court would issue a summons to the offending creatures. A bailiff would walk to the edge of the infested fields and, in a loud, clear voice, read out the official document, ordering the beetles, rats, or flies to appear before the court on a specified date to answer for their crimes. You can just imagine it. A man in formal attire standing at the edge of a pasture, shouting legal threats at a cloud of gnats. It's a level of bureaucratic commitment that feels almost heroic. Of course, the animals rarely showed up. Their failure to appear in court would be duly noted, but this didn't halt the proceedings. Instead, in a remarkable display of legal fairness, the court would appoint a lawyer to represent the absent defendants. This wasn't a joke. This was a real, often ambitious human lawyer tasked with mounting the best possible defense for a swarm of caterpillars. He would argue, for instance, that his clients were also God's creatures, simply trying to eat as God intended. He might argue that the people had failed in their duty to pay their tithes, and this infestation was a divine sign, making his clients instruments of God's will rather than criminals. The entire affair was a slow, deliberate legal drama. Scholars debate the extent to which the average farmer truly believed a priest's curse would stop a locust swarm, versus seeing the trial as a necessary spiritual ritual to get God back on their side. After weeks, sometimes months of legal arguments, the ecclesiastical judge would deliver his verdict. Often, it was a compromise. The pests might be ordered to decamp and remove themselves to a specific, unused plot of land set aside for them. If they disobeyed this judicial order, only then would the church unleash its ultimate weapon. The bishop, with all the ceremony and gravitas he could muster, would pronounce a formal anathema, a curse, excommunicating the entire species from the community of God's creatures and condemning them to perdition. It was spiritual warfare waged through legal procedure. So you had these two tracks: a secular court for a pig committing a felony, and a church court for a class action lawsuit brought against an entire species of insect. It's like the difference between a murder trial and an Environmental Protection Agency hearing, just with significantly more holy water and a complete lack of scientific understanding. Back in this cold stone hall, the sow's fate rests with the law of man. There will be no talk of curses or excommunication here, only the stark, brutal question of the gallows. The very existence of these two court systems, one for the pig and one for the pest, begs a much deeper question. It's a question you can feel hanging in the cold air of the courtroom, unspoken, but present in the solemn faces of the villagers. Why? Why believe an animal can be guilty of a crime in the first place? To us, the idea is absurd. An animal acts on instinct, not malice. It cannot comprehend morality, law, or justice. But to understand the scene playing out before you, you have to peer deeper, past the surface of the law and into the very foundation of the medieval worldview, the Holy Bible. For the people in this room, the world is not a random collection of atoms governed by physics. It is a grand, unfolding story written by God, and every creature, great and small, has a role to play. Their understanding starts, as everything did in the book of Genesis. In the beginning, in the perfect world of Eden, the relationship between humanity and the animal kingdom was one of complete harmony. Adam was tasked with naming all the creatures, and humanity was given dominion over them. To the medieval mind, this established a clear, divinely ordained hierarchy. It was less a gentle stewardship and more of a celestial feudal system, with humanity as the lord and the animal kingdom as the vassal. Animals were subjects in a kingdom ruled by man who was himself a subject of God. But then came the fall. When Adam and Eve were cast out of paradise, the entire world was fractured. The curse of their disobedience rippled outwards, tainting not just humanity, but the very ground they walked on and the creatures they lived with. The harmony was shattered, replaced by conflict, fear, and violence. An animal attacking a human was therefore not just a random tragic event. It was a profound disruption of the natural order. It was an act of rebellion by a subject against its rightful lord, a grim echo of humanity's own rebellion against God. The sow in the dock isn't just a dangerous animal. She is a symbol of a fallen, broken world. Punishing her is a way of symbolically restoring that lost harmony, of reasserting humanity's rightful dominion in a world thrown into chaos. This wasn't just abstract theology. They had explicit biblical law to back it up. Tucked away in the Old Testament is a passage that served as the cornerstone for nearly every secular animal trial. In Exodus chapter 21, verse 28, the law is laid out with stark clarity. If an ox gore a man or a woman that they die, then the ox shall be surely stoned, and his flesh shall not be eaten. For medieval jurists, this was the ultimate precedent. It was not a suggestion. It was God's own law. Notice the details. The law demands the execution of the animal itself. The punishment is separate from any fault of the owner, who is explicitly declared quit, or free from blame. The ox is the guilty party, and the ox must pay the price. For the magistrate in this courtroom, the case of the murderous sow is simply a direct application of this sacred principle. The theological framework got even more complex when it came to the pests tried by the church. While a large domestic animal might simply be acting out of its own fallen nature, vermin, rats, flies, locusts, weevils, were often seen as something more sinister. A quirky but widespread belief held that these creatures were not part of God's original good creation. Instead, they were thought to be direct creations of the devil, or at the very least, stowaways on Noah's Ark, having snuck aboard without a divine invitation, which, if you've ever had to deal with a summer fruit fly infestation, feels like a pretty sound theological argument. This demonic association meant that an infestation wasn't just an agricultural nuisance. It was a direct attack by the forces of hell. The church, therefore, had to fight back with its spiritual weapons, not just to protect the crops, but to wage war against Satan's tiny, creeping armies. This led to all sorts of intricate discussions among the educated elite. Theologians and legal scholars of the era fiercely debated whether a pig that killed a child was acting out of its own simple, brutish nature, or if it was possessed and being used as a vessel by a demonic entity. The distinction was critical. If the animal was an unwilling demonic puppet, was it truly culpable? Or was it more like a living weapon, a stone thrown by a malicious hand? These weren't idle questions. They were at the very heart of how medieval people understood morality, agency, and the constant invisible war between good and evil that played out in their daily lives. Is your pet just misbehaving, or is it a furry little portal to the netherworld? For them, it was a genuinely serious legal and theological question, and the answer determined whether the guilty party was just the animal or something far, far worse. All this talk of theology and legal theory can feel a little abstract, like dust motes dancing in a sliver of light. So let's leave the generalities behind and make this real. Let's allow the vague scene in this anonymous courtroom to sharpen and focus, zeroing in on a specific time and place. You are now in Falaise, Normandy. The year is 1386. The sky is a typically Norman shade of bruised gray, and a damp chill hangs in the air. The story you are about to witness is one of the most famous and well-documented animal trials in history, a case that captures all the strange, terrifying logic we've been exploring. It begins, as these things so often do, with a moment of unimaginable tragedy. In a small home on the edge of town, the 3-month-old son of a stonemason is left unattended for a few fatal moments. A pig, a large sow owned by the family, wanders into the house. What happens next is brutal and swift. The animal, driven by hunger or some unknowable animal impulse, attacks the infant in its cradle, mauling the child's face and arm. By the time the parents rush in, it is too late. The baby, Jean, is dead. In our world, this would be a horrific accident, a source of private grief, and a grim reminder of the dangers of farm life. In 1386 Falaise, it is a crime. It is murder. The sow is immediately seized and, following the letter of the law, thrown into the town jail. There she is held at the public's expense, awaiting a formal trial. The wheels of justice, which can often grind so slowly for humans, move with surprising speed for a porcine felon. A 9-day trial is convened, presided over by the Viscount of Falaise himself. Witnesses are called. Evidence is presented. The grieving parents testify. The facts are not in dispute. The sow is unquestionably responsible for the death of the child. On the 9th day, the Viscount delivers his solemn verdict: guilty. The sentence is read aloud for all to hear. The pig is condemned to be taken to the town square, and there, on a scaffold, to have its snout and foreleg mangled and maimed in a grim reflection of the injuries it inflicted on the baby. Then it is to be dressed in human clothing and hanged by the neck until dead. This isn't just a simple execution to put down a dangerous animal. This is punishment, rich with symbolism, and designed for maximum public impact. It's a ritual cleansing. On the day of the execution, the entire town gathers in the square. It's a public holiday of the darkest sort. You stand among the crowd, pressed shoulder to shoulder with merchants, farmers, and children, all silent and watchful. A procession emerges from the jail. First the bailiffs, then the executioner, and finally, the condemned. The sow is dragged on a wooden hurdle towards the newly constructed gallows. Once on the platform, the first part of the sentence is carried out. Then comes the most unsettling part of the ritual. The executioner, a grimly professional figure, produces a bundle of clothing. He proceeds to dress the wounded, squealing animal in a man's waistcoat, breeches, and most bizarrely of all, he fits white gloves onto its front trotters. It is a matter of debate among historians whether this act of dressing the pig was meant to fully humanize it, making its execution a more morally satisfying spectacle of justice, or if it was a form of profound mockery, a way of reinforcing the absolute boundary between the human community and the chaotic, bestial world that this pig had come to represent. Either way, the effect is deeply unnerving. The animal, now a grotesque parody of a human being, is hoisted up by the rope. And here is a final, wonderfully strange detail. As a part of the official sentence, the Viscount ordered all the farmers in the area to bring their own pigs to the square to witness the execution. It was intended, the records state, as a salutary example to them and to make them wiser in the future. You can see them now, a confused, grunting audience held in pens at the edge of the square, watching one of their own, dressed as a man being hanged from a gibbet. One imagines this had less of a scared straight effect on the assembled swine and more of a, "Why is that one wearing pants?" effect. The sow hangs until it is dead. Justice, as they understand it, has been served. The cosmic balance has been restored. And the whole affair is meticulously documented. The town archives will preserve the receipt for the executioner fee, 10 sous and 10 deniers, plus a new glove. Everything is accounted for, because this was not an act of mob violence or folk superstition run amok. It was the law, enacted in all its terrible, formal, and utterly alien logic. Nothing makes a bizarre historical event feel more real than discovering someone had to fill out an expense report for it. Even a pig execution has a paper trail. As the grim scene in Falaise fades from view and the last of the townsfolk head back to their homes, a quiet thought might settle in your mind. Amidst all the procedure, the witnesses, the judge, and the executioner, one key figure from a modern trial was conspicuously absent. There was no one to speak for the pig, no voice to argue its case, to question the proceedings, or to plead for mercy. The sow of Falaise, like most animals tried in secular courts for capital crimes, faced justice alone. But this wasn't always the case. To find the animal defense attorney, you must turn away from the bloody spectacle of the secular gallows and towards the more cerebral and arguably more bizarre world of the ecclesiastical courts. Remember, these were the church-run courts that handled cases against entire populations of pests. Here, in a stunning commitment to due process, the accused were almost always granted legal counsel. So, let's leave the town square and slip into the quiet, dusty confines of a jurist's office somewhere in 16th century France. The man you see before you, hunched over a heavy leather-bound book, is a lawyer. He's young, clever, and ambitious. The room smells of old parchment, melting wax from the single candle that pushes back the gloom, and the faint, sweet scent of decaying paper. He is preparing his defense for a major upcoming trial. His clients, an enormous population of rats accused of wantonly and maliciously destroying a village's barley harvest. This isn't a joke to him. It's the case that could make or break his career. Legal historians still debate whether these lawyers were genuinely arguing for the rights of animals within God's creation, or if these trials were essentially elaborate intellectual puzzles, a kind of medieval moot court. Taking on the defense of a swarm of insects was a low-risk, high-reward proposition for a young lawyer. If you lost, well, what did anyone expect? They were rats. But if you won, if you managed, through sheer legal brilliance, to get your clients acquitted or their sentence mitigated, you would be hailed as a genius. The most famous of these animal advocates was a man named Bartholomew Chassenet. In the early 1500s, he took on that very case, defending the rats of autumn. He would go on to become one of France's most distinguished legal minds, but he built his reputation on the back of this seemingly hopeless case. He was, in effect, the public defender for vermin, and he took the job incredibly seriously. The arguments he and lawyers like him presented were not frivolous. They were deeply researched, meticulously crafted legal treatises, citing precedents from Roman law, the Bible, and the works of saints and philosophers. Imagine the challenge: You can't exactly have a private consultation with your client when your client is a million beetles currently devouring a nearby orchard. You can't ask them for their side of the story. So you must rely on pure legal theory, and the arguments they devised were masterpieces of creative thinking. For example, in a case against weevils, a lawyer might argue from Genesis that his clients, as creatures made by God, have a fundamental right to sustenance. They are not stealing the crops, he might proclaim. They are merely partaking of the bounty God provided for all living things. The humans, he could argue, were the ones at fault for not providing for his clients through tithes and offerings. One of the most celebrated and clever arguments deployed in these cases revolved around the summons itself. As we know, a court official would go to the fields and summon the pests to appear. When they inevitably failed to show up, the prosecution would demand a default judgment, but the defense attorney would rise and object. He would argue that while his clients had the utmost respect for the court, the summons was invalid because it failed to guarantee their safety on the journey to the courthouse. The roads, he would gravely inform the judge, were filled with his client's mortal enemies, cats and dogs lying in wait. To compel his clients to appear would be to sentence them to death before they even had their day in court. It is the legal equivalent of saying you can talk to make it to your deposition because the traffic is murder, except the traffic is a predator that literally wants to eat you. It's a brilliant, logically sound, and utterly surreal piece of legal maneuvering. So you can see this young lawyer in his study, not as a figure of fun, but as a sharp mind relishing a unique intellectual challenge. He is fighting for a client that cannot thank him, for a cause that seems absurd, but in doing so, he is participating in a profound conversation about the nature of justice, the scope of God's creation, and the place of every living thing within it. He is proving that the law in its majesty extends its protections even to the lowliest of creatures. Or at the very least, he's proving to the wealthy merchants and bishops watching that he's a very, very clever man who you might want to hire the next time your inheritance is on the line. Let's leave that young lawyer to his books for a moment. Let his clever arguments about due process for rats echo in the quiet of his study. Your journey now takes you out of the town, past the stone walls, and into the countryside that surrounds it. You walk along a path that cuts between fields which should, by the grace of God and the hard work of the peasants, be lush and green with the promise of a harvest. But they are not. The air here feels wrong. It's too quiet, lacking the gentle rustle of wind through healthy leaves. Instead, there's a low, persistent humming sound, a sound of chewing, a sound of millions of tiny bodies in motion. You look closer at a vine that should be heavy with grapes, but it's been stripped bare, leaving only a skeleton of woody stems. The ground seems to shift and crawl. This is the scene of the crime. This is the disaster that sets the whole strange machinery of the ecclesiastical court into motion. This is a plague. The defendants in these cases were a varied and voracious lot. In Switzerland, it was the Spanish fly, a beetle whose larvae devoured the leaves of the ash trees. In France, it was legions of caterpillars known as huraburs or cankerworms. Across Europe, it was weevils in the granaries, locusts descending from the sky in deafening clouds, and field mice or moles turning fertile pastures into barren, tunnel-ridden earth. Unlike the singular guilt of the Falaise pig, this was a collective crime. The charge was not murder, but theft on a biblical scale, the theft of a community's future. Faced with a crisis that threatened mass starvation, the people did the only thing that made sense to them. They sued. The process, as you know, was meticulous, but let's imagine you are witnessing a specific, well-documented case from the year 1519 in the Alpine region of Stelvio. The criminals are a population of field mice who have multiplied beyond control and are annihilating the crops. The villagers appeal to the church, and a trial is convened. The mice are appointed a defense attorney, a man named Hans Grinebner, who argues passionately on their behalf. He points out their hunger, their desperation, that they too are God's creatures deserving of life. After hearing all the arguments, the court delivers its verdict. The mice are to be banished. An official ban of ejectment is issued. But the court, in its wisdom and mercy, includes several conditions. The mice are given a grace period of 14 days to depart peacefully. And in a moment of extraordinary legal grace, The verdict includes a promise of safe conduct, a guarantee of protection from their enemies. The villagers are officially forbidden from harming the mice during their exodus, and their dogs and cats are to be restrained. It's like the negotiated settlement of a refugee crisis, complete with a demilitarized zone, but for rodents. How, you might wonder, do you communicate this complex legal ruling to a million mice? This is where ritual takes over. A court official walks through the ravaged fields, reading the verdict aloud at several locations. But sometimes they went a step further, in a practice that perfectly captures the fusion of law and magical thinking. They would capture a few of the offending creatures, a dozen beetles perhaps, or a handful of locusts. These individuals would be held as representatives of the whole. They might be brought into the church to hear the anathema read against them, held in a small box that served as a symbolic prison. Then, after the proceedings were concluded, they would be released. This was a form of parole, granted on the optimistic assumption that these insect ambassadors would return to the swarm and dutifully inform everyone of the court's decree. Historians and theologians continue to explore whether the primary goal of these trials was a genuine, faith-based attempt at pest control, or if it was a form of collective psychological therapy. For a community facing starvation, utterly powerless against the overwhelming force of nature, the trial offered a narrative. It provided a sense of agency. It turned a chaotic natural disaster into a structured conflict with a villain, a hero, and a clear set of rules. You couldn't stop the swarm, but you could sue it. You could feel like you were fighting back. And if the diplomatic solution, the order to leave, the promise of safe passage, failed, if the mice lingered past their 14-day grace period, or the weevils continued their feasting, then came the final, terrible act. A solemn procession of priests, led by the bishop if the crisis was severe enough, would make its way to the fields. There, with bell, book, and candle, they would unleash the church's ultimate weapon, the anathema. It was a formal curse, an excommunication that cast the creatures out from God's grace and protection, condemning them to wither and die. You can hear the sound of the chanting Latin, a heavy, somber sound rolling over a landscape humming with the noise of its own destruction, a last desperate legal appeal to the highest court of all. The solemn Latin curse fades over the fields, a desperate prayer against a creeping, chewing tide. But animal crimes were not limited to simple violence or mass theft. Your journey now takes you away from the ravaged farmlands of France and into the bustling heart of a city. You find yourself in Basel, Switzerland, in the year 1474. The air is dense with the smells of commerce, tanned leather, baking bread, the sharp tang of river water from the nearby Rhine. Here, among the tall, timber-framed houses and wealthy merchant guilds, a trial is underway for a crime so strange, so deeply rooted in fear and folklore, that it makes a murderous pig seem almost logical. You push your way into a crowded public hall which serves as a courtroom. The mood is tense, a mixture of fear and righteous anger rippling through the onlookers. In the defendant's cage is the accused, an 11-year-old rooster. He looks unremarkable, just another farm bird. But this rooster is charged with an act so monstrous, so profoundly unnatural, that it has thrown the entire city into a state of theological panic. This rooster is accused of laying an egg. Now, we've moved beyond the straightforward transgression of a pig killing a child. This is a crime not against a person, but against the very fabric of reality, against God's established natural order. To the people of Basel, a rooster laying an egg was not a biological curiosity. It was an act of profound evil, a sign of the devil's hand at work in their world. And this belief was tied to a very specific and terrifying legend, the cockatrice, or the basilisk. According to widely held medieval lore, an egg laid by a rooster was no ordinary egg. It was a demonic seed. If this unnatural egg were to be hatched, traditionally by a toad or a serpent, it would bring forth a basilisk. This was one of the most dreaded monsters in the medieval bestiary, a reptilian horror whose gaze alone could kill a man instantly. Its breath was poison, its touch was death. The presence of a rooster's egg, therefore, was not a silly farmyard anomaly. It was the potential genesis of a weapon of mass destruction, a demonic plague waiting to be unleashed upon the city. It really raises the stakes for your morning trip to the chicken coop. Are you collecting breakfast, or are you averting the apocalypse? The trial, therefore, is conducted with the utmost gravity. A lawyer is appointed to defend the rooster. You can imagine his predicament. Defending a murderous pig is one thing. How do you even begin to defend a rooster for a crime it didn't know was biologically possible? His argument, as recorded, was sound. He contended that the laying of the egg was an involuntary act. No animal, he stated, could or should be prosecuted for a blind mechanical function of its body. He also argued there was no proof the devil was involved. Perhaps it was just a strange natural mistake. The prosecution, however, played on the deep-seated fears of the court and the public. They argued that the very existence of the egg was evidence enough. The unnaturalness of the act was in itself proof of demonic complicity. They brought the egg into the courtroom, a small, yolkless wind egg, and presented it as one would a murder weapon. This rooster, they thundered, had willingly colluded with Satan to bring a monster into the world. Scholars of folklore and law debate whether the trial of the Basel rooster was driven by a genuine, literal terror of a monster hatching in their city, or if it was a more symbolic prosecution. The rooster, by transgressing its God-given nature, may have been a proxy for other human anxieties about unnatural acts like heresy, witchcraft, or forbidden desires. By putting the rooster on trial, the community could publicly condemn all things that defied their strict moral and natural order, reinforcing the boundaries of acceptable behavior. The verdict, perhaps inevitably, is guilty. The sentence for such a demonic crime could only be one thing: death by fire, the same punishment reserved for witches and heretics. A great pyre is built in the public square. The rooster, along with its accursed egg, is tied to a stake. The entire city turns out to watch. This is not an execution for retribution like the pig at Falaise. This is an act of purification. As the flames leap up, consuming the creature and its demonic potential, the people of Basel believe they are cleansing their community of a profound evil, cauterizing a wound that Satan had tried to open in their midst. And the story has one last, grimly fantastic postscript. After the fire has died down, the city's executioner performs a public dissection of the rooster's charred remains. He announces to the awestruck crowd that he has discovered 3 more of the devil's eggs nestled within the creature's abdomen. For the court and the citizens of Basel, this was the ultimate vindication. Their fears had been real. Their actions had been just. They had caught the demon in the act and stopped it with not a moment to spare. The ashes of the Basel rooster cool in the town square, a grim testament to a community's fear of the unnatural. We've seen a pig hanged for murder, insects sued for theft, and a rooster burned for heresy. These cases are wildly different in their details, but they are all linked by a single powerful thread, a profound and almost obsessive commitment to procedure. This was not chaotic mob justice. This was not a crowd of superstitious peasants simply killing a troublesome animal. What you've been witnessing is the slow, deliberate, and majestic grinding of the wheels of the law. To truly understand this world, you have to appreciate that the how was just as important as the what. Let's imagine you are no longer just a spectator, but a clerk in the service of the court. Your job is to observe and record, to ensure every step is followed to the letter. You sit at a small wooden desk, the sharp, earthy smell of iron gall ink filling your nostrils as you dip your quill. The process begins not with a pitchfork, but with a formal complaint lodged by an aggrieved party. A warrant is drawn up, written in formal Latin, the language of God and the law. This warrant is served by a bailiff, who officially takes the accused animal into custody. The pig is led to the jail. The offending dog is chained in the courthouse kennels. From that moment, the animal is a ward of the court, a defendant with a legal status. In the courtroom itself, every detail from a human trial is meticulously replicated. The same judge in the same robes sits on the same bench. The same bailiffs keep order. Witnesses are called to testify under oath, swearing on a holy relic or a Bible to tell the truth about what they saw the cow do. Everything is done by the book, even if the book doesn't have a chapter on how to handle a defendant who is currently trying to eat the leg of your desk. This entire performance of legal propriety was essential. This concern for fairness could lead to some remarkable arrangements. In some ecclesiastical courts, for example, there was a procedural rule that the animal's defense lawyer had to be of the same age and level of experience as the prosecutor. This was meant to ensure a fair fight, a balanced legal contest. It's a bit like a sports league salary cap, but for preventing a hotshot prosecuting attorney from steamrolling a rookie whose only prior client was a flock of legally ambiguous pigeons. But this procedural mimicry had a much darker side. When an animal was accused alongside a human being, most commonly in cases of witchcraft where the animal was a demonic familiar, or in cases of bestiality, the legal process extended to its most brutal extremes. It is a grim and well-documented fact that animals in these situations were sometimes subjected to torture. The goal was to elicit a confession, either from the animal itself or to corroborate the confession being extracted from its human co-defendant. The animal's cries of pain would be interpreted by the magistrates as affirmations of the human's guilt. It is a chilling example of the system's internal logic taken to its most horrific conclusion, where the pretense of a trial served only to validate a pre-existing belief. Anthropologists and legal historians disagree on the primary function of this rigid proceduralism. Was it all just a performance to give the whole affair a veneer of legitimacy? By dressing up the execution of an animal in the full, solemn regalia of the law, were they simply reassuring themselves that they weren't just killing a beast, but were instead enacting profound justice? Or was it something deeper? Some argue that the procedure itself was a form of ritual magic, a structured way of communicating with the divine. By following the correct legal steps with perfect fidelity, they believed they were creating the proper channel through which God's true judgment could be revealed. Whatever the reason, the result is the same. From the initial arrest to the final verdict, every step is recorded by your quill on the parchment. And when the sentence is passed, it is not shouted by a mob, but read aloud in a formal, droning voice by a court official. And the execution itself is a state function, carried out by a professional who later submits an invoice for his services and materials. This whole process proves one eternal truth. No matter how strange and chaotic a situation might be, a bureaucracy can always find a way to make it orderly, methodical, and then create the proper forms for it. The final stamp of the wax seal on the document before you doesn't just close the case, it affirms the entire worldview that made it possible. The wax seal cools on the final court document. Your work as the clerk is done. The meticulous procedure has reached its inevitable conclusion, a verdict of guilty. Now the full weight of the law, having been so carefully balanced and aimed, is ready to fall. The sentence must be pronounced and carried out. And just as the crimes varied from the mundane to the demonic, the punishments meted out to these animal convicts were a strange and often brutal catalog of humanity's ideas about justice. The sentence handed down depended heavily on which court had tried the case. For the individual animals tried in secular courts, the pigs, dogs, and horses accused of violent crimes against people, the punishments were stark, physical, and almost always final. The most common sentence, as you saw with the sow of Falaise, was death by hanging. The public gallows, that grim stage of human justice, was used without prejudice. An animal convicted of homicide was treated like a human convicted of homicide. In the eyes of the law, the moral stain of the crime was the same, and so the punishment had to be as well. For crimes deemed especially heinous or unnatural, the punishment was elevated. Burning at the stake, the fate of the Basel rooster, was reserved for acts that smacked of witchcraft, heresy, or demonic collusion. Fire was not just an instrument of death, it was an agent of purification, a way to cleanse the community of an evil that was more than just physical. In some rare and horrifying cases, an animal, particularly a pig guilty of killing an infant, might be sentenced to be buried alive, a punishment that mirrored an ancient and terrible sentence for human women who committed infanticide. Often the punishment was tailored to the crime with a grim literalism, following the biblical principle of lex talionis, an eye for an eye. This is a well-documented aspect of medieval animal justice. A pig that had savaged a person's face would, before its hanging, have its own snout and face publicly mutilated. A dog that had bitten someone might have its offending leg broken, or the teeth it used to bite knocked out. It's a very direct system. You bite the postman, you lose your biting privileges. The goal was to make the punishment a mirror of the transgression, a symmetrical and satisfying restoration of order. It remains a point of contention among legal scholars whether these punishments were designed to inflict genuine retributive suffering on the animal, or if they were purely symbolic performances intended for the human audience. Did they truly believe the pig felt the shame and pain as a just punishment? Or was the act of mutilating its face before the crowd a cathartic ritual for the humans who had been harmed and frightened? The answer is likely lost to the past, a mix of both. Meanwhile, in the ecclesiastical courts, the sentences were of a completely different nature. The church did not wield the sword or the rope. Its power was spiritual. For the plagues of insects and vermin, the most common sentence was banishment. The court would formally order the creatures to quit the afflicted lands and remove themselves to a designated, uncultivated area. But if they disobeyed, the court would deploy its ultimate sanction: excommunication and anathema. Imagine being a beetle, just going about your business munching on a grape leaf, and suddenly you and your entire species are declared spiritual outlaws, formally cast out from the grace of God and the community of the faithful. It was a spiritual death sentence, a curse intended to cause the creatures to wither and perish. Not all sentences were so final, however. History records a few fascinating exceptions, punishments that suggest a belief in the possibility of animal penance. In one case, a donkey was sentenced to be confined for life within the walls of a monastery. Its upkeep was to be paid for by a charitable endowment, and it would live out its days in a state of perpetual penance among the monks. It's the medieval equivalent of being sentenced to community service, except your probation officer is a Franciscan friar, and your work involves hauling holy relics. These rare sentences show a side of the system that wasn't just about retribution, but about a strange, hopeful vision of restoring a fallen creature to a state of grace one way or another. Whether it was the gallows, the pyre, the curse, or the cloister, the sentence was always the final act in a long and solemn legal drama. A sentence, whether it's hanging from a gallows or a solemn curse whispered over a field, doesn't just appear out of thin air. It is the final brick placed atop a wall carefully constructed from testimony, exhibits, and evidence. Before any judgment could be passed, a case had to be built. And in the strange legal world of animal trials, the methods for doing so ranged from the surprisingly familiar to the profoundly bizarre. You are no longer just a clerk or a spectator. You are now on the jury, tasked with weighing the proof presented before you. In the secular trials, the ones involving a single animal accused of a violent crime, the foundation of the case was the gold standard of any courtroom: eyewitness testimony. You listen as, one by one, the witnesses are called. A woman from the village of Falaise, her face etched with grief, takes the stand. With her hand on a holy relic, she swears an oath to God to tell the truth. She recounts in harrowing detail the moment she discovered her child, and the pig standing nearby, its snout stained red. Her testimony is treated with absolute gravity. Next, a neighbor is called. He swears he saw the pig push its way into the house just moments before the screams were heard. This is the core of the prosecution's case: human beings under a sacred oath, telling the court what they saw. Then comes the physical evidence. The body of the victim would have been presented to the court or its investigators, the wounds examined to see if they match the capabilities of the accused animal. The animal itself becomes Exhibit A. The prosecutor points to its powerful jaws, its formidable size. In the case of the Basel rooster, the small malformed egg it allegedly laid would have been brought into the courtroom, perhaps resting on a velvet cushion, a tangible piece of unnatural villainy for all to see. This part of the process feels almost modern, a recognizable attempt to link the accused to the crime through observation and fact. But how do you collect evidence against a million weevils? In the ecclesiastical courts, the process was more formalistic. A commission of learned clerics, acting as a combination of expert witness and crime scene investigator, would be dispatched to the afflicted region. They would perform what was known as a visitation, a formal inspection of the damage. They would walk the stripped fields, count the ruined vines, and draft a detailed report on the nature and scale of the infestation. They might even capture a sample of the culprits, presenting a jar full of beetles to the court. Their sworn, notarized report became the primary evidence, the eyewitness testimony against an entire species. This is where the path diverges into much stranger territory. Beyond human testimony and physical exhibits, the court would often consider the behavior of the animal defendant itself as a form of evidence. An animal that remained calm and placid in the dock could be seen as demonstrating a clear conscience. But an animal that squealed, struggled, or acted aggressively could be interpreted as being tormented by its own guilt, its animal soul in turmoil. The defendant's refusal to make eye contact with the magistrate might be noted in the official record, not as a sign of being a confused and terrified animal, but as a clear mark of a guilty spirit. It is a subject of ongoing discussion whether this gathering of evidence was a genuine attempt at fact-finding, or a form of social ritual designed to confirm what the community already believed to be true. This ambiguity is perfectly captured in one peculiar case involving a swarm of bees. After a man was found dead from stings near their hive, the bees were charged with murder. Unable to bring the entire swarm to court, the judge sent a bailiff to the hive to observe their behavior. The bailiff returned and testified that the bees were buzzing in a loud, angry, and agitated manner. The judge took this not as the normal defensiveness of a beehive, but as a collective, buzzing confession. He declared their angry buzzing to be proof of their guilt and a defiant refusal to submit to the authority of the court, and promptly sentenced them to be suffocated. It was a bold legal strategy on the part of the bees, confessing so loudly before their lawyer was even present. The evidence was whatever the human observers needed it to be, a reflection of their own fears and certainties projected onto the silent animal world. The image of the angry, buzzing bees, condemned by their own collective confession, fades into the background. Their case, like the pigs and the roosters, was straightforward in one respect. The animal was the sole defendant. But as you continue to sift through the dusty legal records of this era, a darker and more complex type of trial emerges. Your focus shifts to a courtroom that feels colder, more menacing. The air is thick with a tension that goes beyond simple justice. You look to the dock and you see not one, but two accused figures. One is a human, gaunt and terrified. The other is an animal, a goat, a dog, or perhaps even a cat. They are not on trial for separate offenses. They are co-conspirators, partners in crime bound together by a single terrible accusation. These were the joint trials, and they typically arose from two of the medieval world's greatest taboos, witchcraft and bestiality. Here, the animal was not just a perpetrator of a crime, but an accomplice, an essential participant in a profound sin that threatened the moral and spiritual fabric of the community. In these cases, the legal system's primary goal was not just punishment, but complete and total erasure. The memory of the sin had to be wiped from the earth, and that meant destroying every living participant. In cases of bestiality, the legal and theological justification was direct and terrifyingly clear, drawn straight from the Old Testament. Leviticus chapter 20 commands that if a man lies with a beast, he shall surely be put to death, and ye shall slay the beast. The law was unambiguous. Both parties were deemed culpable. The animal was not seen as a passive, unwilling victim, but as a participant in an act that stained the whole of God's creation. The trial was often a formality. Once the human's guilt was established, often through a forced confession, the animal's fate was sealed along with his. They would be executed together, often burned on the same pyre, so that the ashes of their shared crime could be scattered to the winds, leaving no trace behind. In the witch trials that swept across Europe, the animal co-conspirator played a different but equally sinister role. Here the creature was the witch's familiar, a demonic spirit that had taken on an animal form to serve its human master. The cat that curled by the hearth was not just a pet, it was a spy for Satan. The toad in the garden was a vessel for evil spirits. The dog that followed the old woman was her accomplice in casting spells. Inquisitors would spend hours questioning the accused witch about her familiar. Did it speak to you? Did it drink your blood from a hidden mark on your body? Did it instruct you on how to blight the crops or sour the milk? The animal's presence and behavior were twisted into damning evidence against the human, and the human's confession of witchcraft in turn condemned the animal. Suddenly, your cat ignoring you isn't just rude, it's potential evidence of a pact with a dark lord. Historians and sociologists continue to debate whether the prosecution of animal accomplices was driven more by a literal belief in their demonic agency, or by a desire to ritually cleanse the community of a taboo by destroying every trace of it. Was the goat burned because they truly believed it was a demon, or because its continued existence was an intolerable reminder of the human sin? Yet even within this brutal logic, there were moments of incredible, baffling nuance. Consider the strange but true case from the village of Vanves, France, in 1750. A young man named Jacques Ferrand was condemned to death for crimes committed with a she-donkey. Both were sentenced to hang. But before the execution could be carried out, something remarkable happened. The townspeople, including the local priest and the prioress of the convent, submitted a formal petition to the court on behalf of the donkey. They attested under oath to the donkey's virtuous character. They had known her for years, they wrote, and she had always been a creature of exemplary behavior, known for her gentle and sober nature. She was, they insisted, an unwilling victim of violence, not a willing participant in a crime. It's probably the only time in history a legal document has included the phrase, and furthermore, this donkey has always been a pillar of the community. Incredibly, the court was convinced. The judges issued a formal decree acquitting the donkey. Jacques Ferrand, however, was still executed. It is a perfect, tragic encapsulation of the era's legal mind. A system capable of formally exonerating an animal based on character references, while simultaneously seeing no issue with executing the human involved. The donkey was saved, a lone survivor of a legal system that so often bound human and animal to the same. The story of the virtuous donkey of Vanves, acquitted by the testimony of her neighbors, is more than just a quirky historical footnote. It's a clue. It reveals that the outcome, whether guilt or innocence, was secondary to the process itself. The meticulous trials, the lawyers, the public sentences, all of this elaborate effort wasn't just for the animal's sake. So as you pull back from the individual cases, a larger question comes into focus. What was the real point of it all? If not just to punish a beast, what social and psychological purpose did these strange spectacles serve? To find the answer, you have to understand the terror that a random, violent, or unnatural event could inspire in the medieval mind. When a pig killed a child or a plague of locusts descended, it wasn't just a tragedy or a disaster. It was a rupture in the fabric of the cosmos. It was a sign that the divinely ordained order of the world had been broken. This created a profound and terrifying anxiety within the community. The world suddenly felt chaotic, meaningless, and hostile. God was angry, or the devil was ascendant. Something had to be done not just to fix the problem, but to fix the world. The animal trial was the solution. It was a powerful piece of public theater, a ritual designed to take a chaotic, terrifying event and wrestle it into a structured, understandable narrative. It was a 3-act drama for the entire community. Act 1 was the crime itself, the moment of chaos. Act 2 was the trial, where the chaos was contained within the stone walls of a courtroom. Here, the terrifying event was transformed into a legal problem, subject to rules, arguments, and procedure. The community could watch as their leaders, the magistrate, the bishop, took control of the narrative. Act 3 was the climax, the verdict and the public punishment, the hanging of the sow, the burning of the rooster, the solemn curse laid upon the insects. These were not just acts of retribution. They were the final scene of the play, the moment of catharsis. By identifying a single guilty source for the chaos and then collectively purging it, the community restored its sense of control. The world made sense again. Moral, social, and divine order were all powerfully reaffirmed. The moral order was restored because a crime had been publicly condemned. The social order was reinforced because the authorities had proven they could protect the community. And the divine order was reset because by applying a law they believed came from God, they were realigning their broken world with His will. It's like cosmic tech support. When the system crashes, you find the source of the error, eliminate it, and reboot the whole community. This idea of the trial as a channel for divine will was a core part of their legal thinking. It was similar to the now infamous trial by combat, where two knights would fight a duel to settle a legal dispute. The winner was not seen as the better fighter, but as the one whom God had favored. The legal process was a ritual to reveal God's judgment. In the same way, the meticulous animal trial, with all its procedural steps, was seen as creating the proper conditions for the true, divine verdict to become known. Sociologists of law still debate the degree to which these trials were a top-down imposition of order by elites versus a bottom-up demand for justice and catharsis from the common people. Were the church and state using these spectacles to demonstrate their power and pacify a frightened populace? Or were the people themselves gripped by fear, demanding these rituals to make sense of their world? The truth, most likely, is a complex mixture of both. The power of these spectacles was meant to last. A public execution was a searingly memorable event, a lesson burned into the collective consciousness. In some towns, a particularly noteworthy animal trial would even be commemorated with a public painting or a long narrative poem, displayed in a church or town hall. It served as a permanent record of the time the community faced down chaos and, through the majesty of the law, restored order. It was a grim cautionary tale, ensuring that no one would ever forget the time they had to hang a pig for murder and the profound, terrifying reasons why. A grand public spectacle, whether it's a hanging, a burning, or a solemn procession, serves a powerful purpose. It restores a community's sense of order and provides a cathartic release. But behind every great public work, every piece of civic theater, there lies a quiet, unglamorous reality that is often overlooked. Someone has to pay for it. Justice, especially justice this theatrical, is not free. To understand the full picture, you must now leave the role of the spectator and become, for a moment, the town bursar, the keeper of the books. Your world is not one of theology or law, but of ledgers, receipts, and the cold, hard reality of coin. Let's return to the town of Falaise in 1386. The execution of the murderous sow is over, the crowd has dispersed, and now the bills are coming due. You sit at your desk, a candle sputtering nearby, and open your ledger. Every expense related to this affair must be meticulously recorded, because the Duke's auditors are famously unforgiving. The first entry is for the animal's imprisonment. The sow was held for 9 days in the town jail. The cost for its board and lodging, the same as for a human prisoner, comes to 9 sous. You duly note it down. Then come the execution costs, and this is where the details get fascinatingly specific, because the executioner has submitted a formal invoice. For his services in carrying out the maiming and hanging, he charges a fee of 10 sous and 10 deniers. You dip your quill and record the amount. But that's not all. His invoice includes materials. There is a charge for the new strong rope used for the gallows. There is a charge for the hire of the cart used to drag the condemned pig from the jail to the public square. And then, there is the most famous line item of all, a charge for a new pair of gloves. The executioner required these so that he would not have to touch the unclean criminal beast with his bare hands. This, too, is a public expense. Justice must be done, but it must also be done with the proper, hygienically sound accessories. This is the hidden bureaucracy of the bazaar. Every strange ritual, every solemn procedure generated a paper trail of expenses that had to be settled by the community. These costs were not trivial. An execution could cost as much as a skilled laborer might earn in several weeks. And who paid for it? The people. The funds came from the town treasury, filled by taxes and levies on the very citizens who had gathered to watch the spectacle. Economic historians debate whether the significant public expense of these trials was seen as a necessary civic duty, like paying for road maintenance or defense, or if it was a source of grumbling and resentment among the taxpayers who had to foot the bill. Imagine getting your annual tax notice and seeing a line item for porcine capital punishment or demonic poultry incineration services. You might have a few questions for your local magistrate. The costs associated with the ecclesiastical courts were just as real, though different in nature. Suing a plague of beetles didn't require a hangman, but it did require a budget. There was the cost of the initial investigation, the travel and lodging for the clerical commission sent to inspect the fields. There were the court fees, and there were the lawyers. A brilliant legal mind like Bartholomew Chassenet, famous for defending the rats of autumn, would have his expenses covered by the court that appointed him. The wheels of justice, even when grinding on behalf of rodents, had to be greased with coin. And then there were the costs of the punishment itself. A formal anathema, the curse meant to exterminate the pests, was a grand production. The bishop and his retinue had to travel to the afflicted site. A public procession had to be organized. There were fees for the bell ringers, who would toll the church bells during the ceremony. And there was the cost of the ritual items, chief among them the enormous wax candle that was snuffed out at the climax of the curse to symbolize the extinguishing of the creature's life and grace. Turns out, getting a swarm of insects officially damned by the Almighty was not cheap. Divine wrath, it seems, has overhead. For you, the town bursar, none of this is about theology. It's about balancing the books. You look down at the entry for the executioner's new glove, sign the payment authorization, and reflect that in the end, every great moral drama comes down to a handful of small, carefully counted coins. You close the heavy ledger, the final cost of the executioner's glove duly noted. All of that procedure, all of that solemnity, all of that coin, spent on a conclusion that so often seemed foregone. It would be easy to assume that these trials were nothing more than elaborate rituals for rubber stamping a death sentence, a way to dress up a simple extermination in the fancy robes of the law. And in many cases you would be right. But it wasn't always so. Every now and then, in a flash of legal brilliance, a moment of communal mercy, or a bizarre application of judicial logic, the system produced its most surprising verdict of all: not guilty. Acquittals were, to be sure, exceedingly rare. For a pig caught red-snouted, the evidence was usually clear and the public's demand for retribution was overwhelming. But the fact that acquittals could happen at all is what makes them so fascinating. They prove that the trials were not always mere show. The legal machinery once set in motion had to follow its own rules, and sometimes those rules led to an unexpected destination. Let's travel back to that French village of Vanves in 1750, to the trial of Jacques Ferrand and the she-donkey. You stand in the courtroom as the verdict is about to be read. The expectation is grimly certain. The crime is heinous. The law from Leviticus is absolute. Both man and beast are doomed. But then, a court clerk reads aloud the petition submitted by the villagers. You listen, astonished as the document details not the animal's crime but its character. You hear the words of the parish priest, the church wardens, and the leading citizens, all attesting that they had known the accused donkey for 4 years, and that she had always shown herself to be a creature of virtue and propriety. They describe her as gentle, sober, and well-behaved, both at home and abroad, as if describing a respected neighbor. Their conclusion is that she was not a willing accomplice, but the victim of a violent act, and therefore innocent of all charges. It sets a rather high bar for the rest of us. I'm not sure I could get my entire town to sign a document attesting to my virtuous nature. The judges confer. The argument is persuasive. The collective testimony of a community, led by its spiritual authorities, carries immense weight. And so, the formal decree is issued. The she-donkey is acquitted. You watch as she is led from the courthouse, a free animal, while her human co-defendant is led away to the gallows. It is a moment of staggering cognitive dissonance, yet it is also the system working exactly as designed. The law had weighed the evidence presented and found the animal defendant to be of good character and therefore not culpable. Justice, in their eyes, had been served. These moments of mercy weren't limited to secular courts or crimes of passion. Ecclesiastical courts also produced their share of acquittals, often born from breathtakingly clever legal arguments. In one case in the Aosta Valley of Italy, a swarm of weevils was put on trial for destroying the local vineyards. Their court-appointed lawyer, rather than arguing that his clients hadn't eaten the grapes, presented a brilliant defense based on natural law. He argued that the weevils and their ancestors had inhabited those hillsides long before human beings arrived and planted the first vine. Therefore, he claimed, his clients had a prior right of inhabitancy. They weren't criminals, he asserted. They were the original residents, and it was the humans who were the interlopers. The court, finding the logic of this argument compelling, acquitted the Weevils. Legal theorists have long debated whether these acquittals represent genuine flashes of judicial reason and a nascent concept of animal rights, or if they were simply instances where the legal ritual played out to a different, but equally socially acceptable conclusion. An acquittal, after all, could also restore order. By demonstrating that the law was not a blunt instrument of vengeance, but a nuanced system capable of mercy and reason, the authorities reinforced the legitimacy of the entire social structure. The law was shown to be fair. For every 100 cases that ended on the gallows, these rare acquittals served as a powerful reminder that the outcome was never truly guaranteed, that even for an animal, justice might prevail.
An acquittal, whether for a virtuous donkey or a trespassing weevil, rarely happens by accident. It requires a confluence of circumstances, a receptive court, and very often, a lawyer of exceptional skill and audacity. And in the strange and rarefied field of animal advocacy, no name stands taller than that of Bartholomew. You've heard of him before. The brilliant young jurist who made his name defending the indefensible. Now, let's take you to the scene of his most legendary triumph. You are an apprentice of the law in the French town of Autun in the early 16th century, and you are here to watch the master at work. The case before the ecclesiastical court is a familiar one. The rats of the province stand accused of criminally destroying the barley harvest, a crime that threatens the community with hunger. The prosecution lays out its case, detailing the damage. The court then summons the defendants. A day is set. As expected, not a single rat appears. The prosecutor, smelling an easy victory, demands that the rats be found guilty by default. All eyes turn to the young man appointed to represent the absent rodents. Bartholomew. This is his moment. He rises, calm and respectful. He does not argue the facts of the case. He does not deny that the barley was eaten. Instead, he attacks the procedure. His first argument is a masterpiece of pedantic brilliance. The court, he notes, issued a summons to the rats of Autun, but his clients, he explains, are a dispersed population, living in countless villages and hamlets across the entire diocese. A single summons, read in one town, is insufficient to notify every individual. For the summons to be legally valid, he argues, every single one of his clients must be personally notified. The court, bound by its own strict rules of service, is forced to agree. The judges order that the summons be read from the pulpit of every single parish church in the region. This, of course, creates an enormous delay. The first victory goes to the rats. Weeks pass. The priests read the summons to their uncomprehending congregations and the equally uncomprehending vermin in their parishes. The new court date arrives, and again, the rats fail to appear. The prosecutor, now visibly irritated, again demands a conviction. Rises once more. He begins with an apology for his client's absence. He explains to the court that his clients are not acting in contempt. It is simply that a journey of this magnitude requires preparation. Some of his clients are elderly, he explains. Some are nursing mothers, others are pregnant. They need more time to make the arduous journey to the courthouse. He respectfully petitions for another Again, the court, committed to the principle of giving every defendant adequate time to appear, grants the delay. Finally, the third court date arrives. The rats are, once again, nowhere to be seen. The prosecutor is practically incandescent with rage. This is a mockery of the courts, a clear and final act of defiance. He demands an immediate verdict and the pronouncement of the anathema. This is the end game. Rises for his final and most famous argument. He begins by stating that his clients, the rats, are eager to attend the trial and answer the charges. They recognize the authority of the court. There is, however, an obstacle. The court has a solemn duty to guarantee the safety of any defendant traveling to its doors. But, explains gravely, the roads and fields are swarming with a deadly menace. The villagers' cats, These cats, he argues, are the mortal enemies of his clients and are lying in wait to ambush them on their journey. For the rats to attempt to come to court would be a suicide mission. Therefore, he formally petitions the court to issue an injunction against the cat owners of the province, ordering them to confine their animals and post a substantial bond to guarantee the rats' safe passage. The courtroom is stunned into silence. The judges look at the villagers, who, of course, scoff at the idea of putting up their own money to ensure their cats do harm the very rats who are eating their grain. Has them. With the villagers refusing to guarantee safe passage, the court cannot fulfill its duty to protect the defendants. Therefore, the rats' failure to appear is not a crime, but a legally justifiable act of their absence is excused. The case is dismissed. The rats, thanks to the breathtaking legal gymnastics of their lawyer, are acquitted. It is still a matter of scholarly discussion whether defense was a sincere legal argument or a brilliant satirical performance designed to expose the absurdity of the proceedings by using their own logic against them. What is certain is that he took the field seriously, even writing a major legal treatise on the subject. A how-to guide for prosecuting and defending animals. Whether he was a true believer or just the cleverest man in any room he entered, his legend was secure. He had faced the full weight of the law on behalf of the lowest of clients, and through sheer intellectual force, he had won.
Bartholomew Chassonet's brilliant, layered defense of the rats of Autun is a monument to legal creativity. But to even begin to construct such an argument, you have to accept the foundational premise of the entire system, that an animal, like a rat or a pig, can be a legal entity, a party to a lawsuit. This simple fact pushes us out of the courtroom, beyond the ledgers of the town bursar, and into the quiet candlelit study of the medieval philosopher. Here, a much deeper and more difficult question is being debated, a question that underpins every single trial we've witnessed. Can an animal have a soul? And if so, can that soul be held accountable for a crime? You sit in this quiet room, the air smelling of beeswax and ancient parchment, and you ponder the central dilemma. For a crime to exist, there must be intent or mens rea, a guilty mind. But can a pig have a guilty mind? Can a dog truly feel malice? Or a rooster understand the demonic implications of its own biology? The answer depended entirely on which school of thought you followed, and the thinkers of the Middle Ages were far from united on the subject. The dominant orthodox position was laid out by the great 13th century theologian, St. Thomas Aquinas. Drawing heavily on the recently rediscovered works of Aristotle, Aquinas proposed a neat hierarchy of souls. At the bottom were plants, which possessed a simple vegetative soul, responsible only for growth and reproduction. Above them were the animals. They had a more advanced sensitive soul, which gave them the ability to perceive the world, feel pleasure and pain, and act on instinct and appetite. But at the very top of the earthly pyramid were human beings, uniquely blessed with a rational soul. This was the soul that provided reason, intellect, free will, and the ability to make a moral choice between good and evil. According to this tidy framework, an animal simply lacked the spiritual hardware to commit a sin. A pig that killed a child was not acting out of moral evil, but out of a corrupted base instinct, a glitch in its sensitive soul. So if the pig couldn't be a sinner, why punish it? For a thinker like Aquinas, the punishment was not for the pig's salvation, but for humanity's. The act, though not a sin for the animal, was still a horrific violation of the God-given order. The public trial and execution were a necessary ritual to repair that cosmic tear, to restore balance in the human world, and to reassert mankind's dominion over a fallen and chaotic natural world. The pig's death was a symbolic statement for the benefit of human souls, not the animals. But this clean explanation wasn't enough for everyone. The Bible itself, with its law about stoning the ox, seemed to imply a more direct form of animal guilt. This led to a fierce argument that raged in universities and monasteries. Philosophers of the period were deeply divided on whether an animal's harmful actions stemmed from its own corrupted, post-fall nature, a kind of brutish, innate malice, or if it was merely a passive instrument for demonic forces. Was the sow of Falaise a murderer in its own right, or was it just a living weapon, possessed and wielded by a demon? The trial in this light becomes an investigation into the very nature of the evil that had been committed, And then there were the more radical, heretical beliefs bubbling under the surface of mainstream theology. Groups like the Cathars in southern France were condemned by the Church for many beliefs, including their adherence to the idea of reincarnation. They believed that human souls after death could be reborn into animal bodies as a form of penance. This, of course, changes everything. If you believe this, the dog that bit a villager might not just be a dog. It could be a sinful human soul working through a karmic sentence. Suddenly, the animal trial becomes a trial of a hidden person, and the stakes become infinitely higher. This idea adds a whole new layer of stress to daily life. Is the goat that keeps eating your laundry just a goat? Or is it your late Uncle Gregory, still upset about how his will was executed? This complex, swirling debate about the nature of the animal soul is the intellectual engine that powered the whole strange legal machine. It allowed a judge to look at a pig in a dock and see not just a farm animal, but a legal problem that had to be solved for the good of the entire Christian world. The dusty, book-filled room of the philosopher fades away. The complex arguments over the nature of the sensitive soul and the rational soul, the debates over demonic possession versus innate malice, this was a conversation happening within a very specific world. It was a debate conducted in Latin, within the stone walls of Christian European universities and monasteries. The entire legal and theological framework that you've been exploring, from the Book of Exodus to the philosophy of Aquinas, is a product of one particular civilization. But what about the rest of the world? Your journey must now expand. You leave the familiar muddy lanes of medieval France and the alpine villages of Switzerland. You travel beyond the borders of Christendom, searching for parallels. Was the courtroom in Falaise the only place on earth a pig could be put on trial? Were European insects the only ones to be threatened with a lawsuit? You travel south, across the Mediterranean, to the great cities of the Islamic world, to Cairo or Damascus. Here you find a rich and deeply sophisticated legal tradition in Sharia law. You find laws governing every aspect of life, from commerce to marriage to criminal justice. You find detailed rules about property and liability. If a man's ox gores another man, the owner is held responsible. But what you do not find are trials for the ox itself. The animal is treated as property, as an instrument. The legal and moral culpability rests entirely with its human owner. The idea of granting the animal legal personhood, of serving it a summons and appointing it a lawyer, is entirely absent. There is no theological imperative for it, no biblical precedent in their tradition that demands it. Your journey continues eastward. You find yourself in the vast, highly organized empire of Ming China. Here, another of the world's great legal systems holds sway. The imperial code is a monument to bureaucratic precision, with rules and punishments for every conceivable human transgression. And again, you find laws dealing with animals. There are regulations about livestock, rules about compensating a farmer for a sheep killed by a neighbor's dog. But the dog is not put on trial. The legal focus is on the human owners and their responsibilities. The Confucian worldview that underpins the legal system has no place for the concept of an animal sinner. The search continues across the globe, to the Americas before European contact, to the empires of India and the kingdoms of Africa. And everywhere, the result is the same. While many cultures have traditions of punishing animals that cause harm, the specific peculiar practice of a formal judicial trial seems to be missing. It turns out that most of the world, when faced with a murderous pig, decided to skip the legal paperwork and go straight to the barbecue. It was a faster, and arguably more practical path to justice. So why was this a uniquely European phenomenon? It appears to have required a very specific cocktail of cultural ingredients that didn't exist anywhere else. You needed the foundation of Roman law, with its elaborate procedures and concepts of legal personhood. You needed the specific Old Testament laws that seemed to grant animals moral culpability. You needed the unique theological anxieties of medieval Christianity, with its deep-seated fears of the devil and its obsession with a divinely ordained natural order. And you needed the dual court system of church and state, creating two separate venues for these strange prosecutions to unfold. Anthropologists and legal historians continue to investigate whether certain folk traditions of punishing animals in other cultures can be considered informal trials or are a completely different phenomenon. But the formal state-sanctioned legal proceeding seems to be an invention of medieval Europe. That's not to say the idea hasn't had strange echoes elsewhere. In a bizarre throwback, a people's court in Tripoli, Libya, placed a pack of 8 dogs on trial in 1974 for allegedly biting a child. But this was more a piece of modern political theater than a serious theological exercise. For the most part, the practice of trying animals remains a historical curiosity, a strange legal detour taken by one culture for a few hundred years, a chapter of jurisprudence that the rest of the world simply decided to skip. So the formal animal trial, with its lawyers and judges and biblical justifications, appears to have been a uniquely European affair, a product of a very specific legal and theological climate. The system was built on the complex philosophical idea that an animal, possessing a sensitive soul, had enough agency to be a legal actor, to be a defendant in a court of law. But this raises a fascinating question that pushes right at the boundary of that logic. What happened when a death was caused not by a living creature, but by a lifeless thing? What happens when the killer isn't a pig with a soul, but a runaway cartwheel with only an axle? To answer this, you must leave the familiar courtroom of the animal trial and enter the world of the coroner's inquest, particularly in medieval England. You stand on a muddy road, a small group of somber men gathered around a body. A man, a farmer, has been crushed by a cart. The cause of death is clear. But the work of the jury here is not just to name the cause, but to identify the killer. And in this case, the killer is the cart itself. This brings us to a legal concept as strange as any animal trial, but fundamentally different: the law of the deodand. The word comes from the Latin deodandum, meaning to be given to God. Under English common law, a practice that lasted until the 19th century, any inanimate object or animal that was the direct cause of a person's death was declared forfeit to the crown. The object was considered tainted, accursed by the life it had taken. To cleanse the community of this taint, the object had to be seized, sold, and its value was often given to the church to pay for masses for the soul of the victim, literally, given to God. This was not a trial. The cartwheel was not arrested and given a lawyer. There was no charge, no defense, no verdict of guilt. The object was not a criminal. It was a cursed thing that had to be dealt with. Legal philosophers have long wrestled with the question of where, precisely, the medieval mind drew the line between the culpability of a living creature, which possessed at least a sensitive soul, and that of a deadly but lifeless thing. The line is subtle but crucial. The pig was a defendant capable of crime. The cartwheel was a deodand, an object of ritual forfeiture. Imagine you're on that coroner's jury. The legal questions are surprisingly complex. What exactly is the deodand? Was it only the one wheel that struck the fatal blow? Was it the entire cart? What about the horse that was pulling it? Or the cargo of hay the cart was carrying? These were serious legal debates. Often the entire moving object, horse, cart, and cargo, was declared the deodand. The records are full of such cases. A ship's anchor that fell on a sailor, a bell that fell from its steeple, a tree that fell on a woodcutter. All were declared deodand, their value forfeited to purge the stain of death. It was the world's most aggressive form of product recall. This is the key difference. The animal trial was a criminal proceeding, rooted in the idea of justice and punishment. It was a moral drama. The deodand was a civil forfeiture, rooted in the idea of ritual purification and superstition. The sow of Falaise was dressed in human clothes and hanged from a gallows as a murderer, a public spectacle of retribution. The cursed cartwheel was simply taken away, its value repurposed to pray for the dead. It seems deeply unfair to the inanimate object community. Where was the Bartholomew Chassenet for accused swords and malevolent millstones? The law of the deodand shows us the edge of the medieval legal imagination. They could grant a pig the legal standing to be a criminal defendant, but they could not do the same for a stone or a sword. The sensitive soul of the animal was the dividing line. The pig was a fallen subject of God's kingdom, capable of a kind of rebellion. The sword was just a thing, a tool that, through tragic accident, had become imbued with the taint of death. Both systems were designed to restore order in the face of a terrifying random event, but they took two very different paths to get there, one through the courtroom, the other through the coroner's inquest. The English coroner puts away his notes on the deodand, the cursed cartwheel that must be given to God. The process is one of ritual purification, of dealing with an object tainted by death. But as you cross back into continental Europe, particularly as the 15th and 16th centuries darken with paranoia, you find a new and terrifying fusion of beliefs. You encounter an animal that is not just a criminal, like the pig, or a tainted object, like the cartwheel. This is an animal believed to be evil by its very nature, a creature that is not just an actor in a crime, but a vessel for the devil himself, the witch's familiar. If you picture the history of bizarre justice as two overlapping circles, one is the tradition of the animal trial, and the other is the hysteria of the great European witch hunts. In the space where they intersect, you find the familiar. This is where the legal prosecution of an animal merges with the theological persecution of a heretic, creating a hybrid of terror that amplified the worst aspects of both. The familiar was not a pet. In the eyes of the witch hunter, it was a demon, a subordinate spirit that had taken the form of an animal to serve its witchmaster. Cats, especially black ones, were the most common suspects. But the list was long. Toads, weasels, dogs, birds, even insects. The familiar had a job description straight from hell. It was a spy, reporting on the villagers' doings. It was a magical assistant helping to cast spells, blight crops, and create potions. And most importantly, it was the witch's direct, physical link to the demonic realm. This belief was not just a vague folk superstition. It was codified and legitimized in one of the most infamous books ever published, the Malleus Maleficarum, or the Hammer of Witches. First printed in 1487, this book became the essential handbook for inquisitors and magistrates across Europe. If you were a witch hunter, this was your guide. It laid out in excruciating detail how to identify, prosecute, and punish witches. And it had plenty to say about their animal accomplices, providing a theological and legal blueprint for treating a household pet as a co-conspirator in a diabolical plot. This is where the procedures of the animal trial were co-opted for a darker purpose. The animal would be arrested and tried alongside the accused witch, but the evidence was of a completely different sort. The prosecution wasn't interested in eyewitnesses to a physical crime. They were interested in evidence of a supernatural pact. And one of the most sought-after proofs was the witch's teat or devil's mark. Inquisitors would forcibly search the body of the accused, looking for any unusual mole, wart, or skin tag. This, they claimed, was a hidden teat from which the familiar suckled the witch's blood as nourishment. It was considered irrefutable physical evidence of a demonic bond. It was a very stressful time to have an unusual skin condition. Historians continue to debate the extent to which the detailed mythology of the familiar was a genuine pre-existing folk superstition that the courts simply absorbed, versus a sophisticated theological concept developed and imposed from the top down by inquisitors to fit any pet into their narrative of a demonic conspiracy. Was this the people's fear being weaponized by the elite, or the elite's theology terrifying the people? This fusion of beliefs had a chilling effect. It created a new and terrifying lens through which to view any animal behavior. Before, if a pig killed a child, it was a straightforward, if tragic, crime. But now, during the height of the witch craze, the question was more sinister. Was it just a pig? Or was it a demonic familiar, sent by the old woman who lived down the lane and was known to harbor stray cats? Any animal crime could now be reinterpreted as an act of witchcraft, and any pet could be recast as a potential demon. The animal trial, which was already a strange legal detour, now found itself merging onto a highway of paranoia, a path that would lead thousands of people and their unfortunate animals to the gallows and the stake. The terror of the witch hunts was a wildfire that swept across much of Europe, its dark smoke of paranoia drifting into courtrooms from Scotland to Poland. But the older, stranger tradition of the animal trial was different. It was less a wildfire and more a great river system, with a powerful central current and a host of regional tributaries and backwaters, each with its own unique character. The practice was not monolithic. To truly understand it, you must become a traveler, crossing the invisible borders of medieval Europe to see how this strange custom changed with the local landscape and culture. Your journey begins in what historians call the hot zone. This is the heartland of the animal trial, a broad swath of territory encompassing France, the Holy Roman Empire, especially its German-speaking lands, Switzerland, and parts of northern Italy. It is here that the river flows strongest. This is where you find the overwhelming majority of recorded cases, both secular and ecclesiastical. In France, you find the classic model of the secular trial. The case of the Sow of Falaise is the archetypal example, a domestic animal, an individual crime, and a prosecution that follows the letter of the law with painstaking precision. The French legal mind seemed to savor the procedural correctness of it all, ensuring every step was just so before the final grim punishment was carried out. As you travel east into the Swiss cantons and the patchwork of states that made up the Holy Roman Empire, the flavor of justice changes. This region was a crucible for all kinds of religious and superstitious anxieties. It's no coincidence that this area was also a major center of the witch hunts. Here, you find not only the classic pig trials, but also the most profoundly bizarre cases, like the Basel rooster condemned for its unnatural egg. There appears to have been a heightened sensitivity to acts that were not just criminal, but demonic, a deep fear of the devilish hand at work in the world that manifested in their prosecution of both beasts and their human neighbors. But as you travel to the edges of the map, the river of animal justice begins to thin and disappear. You cross the Channel to England. Here, if a pig kills a child, the community is no less horrified, but their legal response is entirely different. There is no trial for the pig. No lawyer, no judge, no verdict. Instead, as you know, the English court would convene a coroner's jury, which would declare the pig a deodand. The animal would be forfeited to the crown, its value used for a charitable purpose. The English looked at the elaborate French system and seemed to say, "A bit too much fuss, isn't it? Let's just take the pig and call it a day." It's a different legal tool to achieve a similar social end. You travel south to the sun-baked Iberian Peninsula. In Spain and Portugal, formal animal trials of the French style are much rarer. But here you find a unique local custom that pushes the logic to a whole new place. You find records of the prosecution of church bells. In an age of faith, the tolling of a consecrated church bell was believed to ward off evil spirits, and specifically, the demons who were thought to cause lightning storms. The bells had a sacred duty. If a bad storm struck and the bells failed to ring, they could be seen as negligent. The bells themselves could be put on trial, formally excommunicated, and sentenced to be recast, a process that was seen as a form of purification and reconsecration. It takes a special kind of legal imagination to prosecute a 2-ton bronze bell for dereliction of duty. Historians of law are still exploring the complex reasons why the practice of formal animal trials flourished so intensely in the Franco-Germanic regions, while failing to take root elsewhere. Was it the deeper inheritance of Roman law in those areas? A particular kind of political fragmentation that allowed local courts more autonomy? A more fervent strain of theological anxiety? There is no single, simple answer. But what is clear is that this strange chapter in legal history was not a universal one. It was a regional specialty, a product of a specific time, a specific place, and a specific set of fears. Your journey across the strange medieval map of animal justice is complete. You've seen the regional variations, from the sober legalism of France to the mystical anxieties of the German lands. This world, with its peculiar logic and deeply held beliefs, could only exist when held together by a certain kind of glue. A shared, unshakable faith in an enchanted reality, a world where God and the devil intervened daily, where curses were real, and where the natural order was a fragile moral construct. But as the 16th century gives way to the 17th and 18th, a new intellectual climate begins to sweep across Europe. A wind of reason and skepticism starts to blow, and the old glue begins to dissolve. You are no longer in a cold, stone courtroom. You find yourself in a Parisian salon or a London coffee house. The room is bright, lit by large glass windows. The air smells of coffee, tobacco, and fresh printing ink from the pamphlets and newspapers being passed from hand to hand. The talk is not of demons and divine curses, but of science, philosophy, and the power of human reason. This is the dawn of the Enlightenment, and its new ideas will prove to be a death sentence for the entire tradition of the animal trial. The first and most devastating blow was struck against the very heart of the system, the concept of the animal soul. You pick up a book by the great French philosopher René Descartes. As you read, you feel the foundations of the old world begin to crumble. Descartes argues that animals are nothing more than complex biological machines. They have no souls, no consciousness, no thoughts, no feelings. They are, in his famous phrase, beast machines. A dog that whimpers when kicked is not feeling pain. It is merely the sound of a mechanism reacting to a stimulus, like the chime of a clock when it is struck. Your dog isn't your loyal friend. It's a furry, meat-powered automaton. It was a rather bleak outlook for pet owners, but for the legal system, it was a revolution. If an animal is just a machine, it cannot have intent. It cannot possess a guilty mind, and if it cannot be guilty, it cannot be put on trial. Prosecuting a pig for murder suddenly becomes as philosophically absurd as prosecuting a falling roof tile. At the same time, the new spirit of scientific inquiry was providing alternative explanations for the disasters that were once blamed on the supernatural. The plague of locusts was no longer seen as a demonic attack or a divine punishment. Naturalists were studying insect life cycles, weather patterns, and ecology. An infestation, they argued, was a natural phenomenon, not a moral one. You can't sue a weather front. You can't excommunicate a high-pressure system. The world was slowly being disenchanted, its mysteries explained not by theology, but by biology and physics. Even the bedrock of biblical authority began to crack under the pressure of critical inquiry. Scholars started to treat the Bible as a historical document, subject to interpretation and context, rather than the unerring, literal word of God. That law from Exodus about stoning the ox? Perhaps it was a specific rule for an ancient pastoral society, not a timeless legal command applicable to 18th century Europe. And finally, the old ways were attacked not just with reason, but with ridicule. The great satirists of the Enlightenment, like Voltaire, wielded mockery as a devastating weapon. They seized upon practices like animal trials, holding them up as perfect examples of the ignorance and superstition of the Dark Ages. It is hard for a magistrate to preside over the trial of a group of weevils with a straight face when the most famous writer in Europe has just published a brilliant, widely read essay about how profoundly ridiculous the whole idea is. Historians of science and philosophy still debate how quickly these new intellectual ideas trickled down from the educated elite to influence the legal practices in the countryside. The old beliefs lingered for decades, but the intellectual and philosophical foundation for the trials was rotting away. The judges, lawyers, and theologians who ran the system were now reading Descartes and Voltaire. They were beginning to live in a different world, a world with less room for cursing caterpillars and soul-bearing swine. The age of the animal trial was, inevitably, coming to a close. The coffee houses and salons of the Enlightenment were buzzing with new ideas. But ideas can take a long time to travel from the fashionable avenues of Paris to the quiet, muddy lanes of a rural village. The great intellectual currents of the age were a slow-acting poison to the tradition of the animal trial. The old beast of superstitious justice was dying, but it took a surprisingly long time to finally breathe its last. The end, when it came, wasn't a sudden event. It was a slow, sputtering fade-out. A series of final, strange cases that feel like echoes from a world that had already vanished. You are now a historian, sifting through the archives looking for the last recorded instances of this bizarre legal custom. You notice a pattern. As the 18th century progresses, the trials become less frequent. They retreat from the major towns and cities, finding their last refuge in remote, isolated provinces, the final holdouts of the old ways of thinking. The practice didn't go out with a bang, but with a whimper, and the confused grunt of one last pig on a witness stand. One of the very last. Fully documented secular trials is a case you have heard before, the 1750 trial of the she-donkey of Vanves. We've viewed it as an example of an acquittal and a joint trial, but its date is just as significant. This was the France of Voltaire, of Diderot, and the great Encyclopédie. The intellectual heart of Europe was pulsing with radical new ideas about reason and nature. And yet, in a small village just outside Paris, a court was still solemnly weighing the moral character of a donkey and condemning a man to death alongside it. The case stands as a stark reminder that history is not a neat and tidy progression. The old world and the new often exist side by side, sometimes in the very same courtroom. The final gasps of the ecclesiastical trials are harder to pinpoint, as their records are more diffuse. But one of the last major cases seems to have been in a French court in 1733, which heard a complaint against a plague of insects. You can imagine the scene: the priests carrying out the ancient rituals, reading the formal summons and the threat of anathema, a ceremony that must have felt archaic and perhaps a little hollow even to them. It was a final performance of a drama that was closing for good. So why did the curtain finally fall? The intellectual reasons, the rise of science and rationalism, were the primary cause, but they were reinforced by practical top-down changes. Throughout the late 18th and early 19th centuries, the legal systems of Europe were being reformed and codified. New comprehensive legal codes, like the famous Napoleonic Code of 1804, were being written. These were rational, secular documents designed for a modern state. They had much to say about contracts, property, and human rights, but they were strangely silent on the legal standing of caterpillars or the proper method for executing a homicidal horse. There was simply no place for an animal defendant in these new, streamlined legal machines. It's a point of historical debate whether the practice ended because of this top-down legal reform, driven by enlightened elites rewriting the law books, or a more gradual bottom-up change, where ordinary people simply stopped believing in the efficacy of the trials and no longer brought such cases to court. Did the supply of cases simply dry up as the old fears and beliefs faded? The most likely answer is that both happened at once, the new laws meeting a population that was already, for the most part, ready to let the old ways go. Our modern fascination with the topic, however, makes us wish for one last, definitive case. And popular history sometimes offers one up: the story of a dog, tried and sentenced to death for its part in a murder and robbery in Delemont, Switzerland, in 1906. The story is a tantalizing one, a bizarre legal fossil discovered in the 20th century, but nearly all professional historians agree that the story is apocryphal, likely a journalistic invention or a local tall tale. We love the idea of a 20th century dog trial because it feels so wonderfully out of place, like seeing a knight in full armor ordering a latte. It's probably not true, but it speaks to the enduring strangeness of the real history, a history that quietly petered out in the fading light of the 18th century. The last dusty file from the 18th century is put away in the archive. The book is closed on the strange history of the animal trial. The practice is dead, a relic of a superstitious past, swept away by the clear, bright light of reason. Or is it? Perhaps the practice isn't dead at all. Perhaps it's just sleeping, and its spirit now haunts our own legal system in a new and unexpected form. The questions that the medieval jurists wrestled with, about an animal's place in our world, about its relationship to the law, have not gone away. In fact, they are more alive and more urgent than ever. You step out of the historical archive and into the modern world. Here, the idea of putting a pig on trial for murder seems laughable. Following Descartes, our legal system is built on the foundational idea that animals are property. You own your dog in the same way you own your sofa. If your dog bites someone, you are liable, as the owner of a dangerous piece of property. If someone harms your dog, they have committed an act of vandalism or destruction of property. It's a neat, tidy, and unemotional framework. But if you look closely, you can see the cracks beginning to form in that foundation. The medieval world put animals on trial because they believed animals had duties and culpability. They were legal actors who could be held responsible for their crimes. Our modern world is witnessing a great reversal. The debate is no longer about animal guilt, but about animal rights. The question is not whether an animal can be a defendant, but whether it can be a plaintiff. We've gone from suing pigs for murder to suing on behalf of pigs for their living conditions. You have to admit, the pigs have definitely hired better lawyers. This shift is creating some truly strange and fascinating legal questions. Consider the existence of animal trusts. In many places, it is now legally possible to leave a portion of your estate in a trust fund for the care of your pet after you die. This is a profound departure from the simple idea of animals as property. A trust requires a beneficiary. The law, in a very real sense, is recognizing your cat as a legal entity capable of benefiting from a will. Your cat can now have a better funded retirement plan than most people, and sometimes these questions explode into the public sphere in the most surreal way. You may have heard of the monkey selfie case. A few years ago, a wildlife photographer left his camera unattended, and a curious crested macaque named Naruto picked it up and snapped a series of selfies. When the photographer published the photos, the animal rights organization PETA sued him on behalf of the monkey, arguing that Naruto, as the creator of the image, was the legal owner of the copyright. The case went all the way to a U.S. federal appeals court. For months, some of the best legal minds in the country were earnestly debating the intellectual property rights of a monkey. The court ultimately ruled against Naruto, but the case was a landmark. The old medieval question, can an animal be a party to a lawsuit, was back, but in a strange new form. Modern legal ethicists are in a heated debate over whether granting animals limited legal rights like the right not to be tortured, or even a form of legal personhood, for highly intelligent species like chimpanzees or dolphins, is the next logical step in our expanding moral circle, or a dangerous blurring of the lines that protect human uniqueness. The conversation sounds startlingly similar to the old scholastic debates about the animal soul, just phrased in the modern language of jurisprudence and cognitive science. We are still, it seems, trying to figure out exactly where the animal kingdom fits into our human-centered world. The ghosts of the sow of Falaise and the rats of autumn are still there, lurking in the footnotes of every animal rights lawsuit. The bright modern courtroom with its debates on monkey copyrights fades away, and you find yourself back where you started, in the quiet of your own mind, trying to make sense of a past that feels stranger than fiction. You've journeyed through the legal procedures, witnessed the executions, explored the philosophical debates, and traced the last dying embers of the practice. But now, as our journey together nears its end, we must return to the most fundamental and difficult question of all. Why? Why did they do it? What was really going on inside the minds of the people who put a pig on trial for murder? The central debate among historians today is not whether these trials happened, the evidence is overwhelming, but how to interpret them. There is no single, easy answer, no Rosetta Stone that unlocks the medieval mindset. Instead, there are several compelling, overlapping theories, each of which reveals a different facet of this strange historical jewel. The first and most straightforward theory is that we should simply take them at their word. This is the theory of genuine belief. In a world saturated with faith, where the boundary between the natural and the supernatural was porous, people genuinely believed that animals could be culpable agents of good or evil. They believed the devil could possess a pig, that a rooster could commit an unnatural act, and that a formal legal curse was the proper way to deal with a plague of insects. In this view, the trials were not a metaphor or a spectacle. They were a literal, good-faith attempt to apply God's law to a fallen world, a desperate effort to impose divine justice on a chaotic reality. But other historians see a more cynical, worldly motive at play. This is the theory of social control. From this perspective, the trials were a powerful tool used by the authorities, the church and the nobility, to demonstrate their power and reinforce the social hierarchy. When a community was gripped by fear, the trial was a way for the elites to show that they were in charge, that they had the tools to solve any problem, no matter how strange. This theory has a particularly sharp edge when it comes to the ecclesiastical trials. Some have argued that the trials against pests were a form of divine protection racket. The priests would arrive in the village and suggest that the locusts were a divine punishment for the villagers' failure to pay their tithes. The trial and the curse were a service the church could provide, but the implicit message was clear. Keep the donations flowing, or we can't guarantee you'll be safe from God's six-legged wrath. A more recent and very influential interpretation views the trials not as a tool of oppression, but as a form of communal therapy. This is the social trauma theory. Imagine the horror and grief in a village after a child is killed by an animal. It's a random, meaningless, and deeply traumatic event. The trial, in this view, is a coping mechanism. It takes the unbearable chaos of the event and transforms it into a structured narrative. It creates a villain, the pig, heroes, the legal authorities, and a clear plot of crime, investigation, and punishment. The public execution provides a cathartic climax, allowing the community to collectively process its fear and grief and feel that order has been restored. The trial wasn't about the pig, it was about healing the wounded psyche of the human community. Finally, there's the theory of the intellectual game. This applies mainly to the brilliant, complex defenses in the church courts. For a lawyer like Bartholomew Chassanet, was the trial of the rats a matter of sincere faith? Or was it an irresistible intellectual puzzle, a chance to show off his mastery of legal rhetoric in a low-stakes environment? In this view, the trials were a kind of medieval moot court, a sophisticated game for the legal elite, played out with real-world consequences for the vermin involved. So which one is true? The most likely answer is all of them, all at once. The motivations of a grieving mother in Falaise were surely different from those of the bishop who sued a plague of weevils, or the ambitious young lawyer defending them. The animal trial was a complex institution that could serve many purposes simultaneously. It was a genuine act of faith for some, a tool of control for others, a source of communal comfort for many, and a fascinating intellectual challenge for a select few. It was a historical potluck. The peasants brought the terror, the church brought the control, and the lawyers brought the ridiculously clever argument that no one asked for, but everyone was impressed by. The books on the historian's desk are closed. The competing theories of genuine faith, of social control, of communal therapy, of intellectual games, have all been weighed and considered. And yet, after all the analysis and all the explanations, the central image remains, as stark and as strange as when we first encountered it, a pig standing in a courtroom, accused of murder. It's a corner of history that feels as though it were written during a fever dream, a story so absurd that it seems it must be a fable. But it was real. Every invoice, every witness statement, every solemn death sentence was meticulously, bureaucratically real. As our long journey together comes to an end, you can let all of those details begin to soften and merge. You can feel yourself walking away from the archives, the scent of old paper and leather fading behind you. You carry with you a collage of strange and vivid memories. You can still see the determined face of Bartholomew Chassanet, conjuring brilliant legal arguments from thin air to save a population of rats. You can feel the heat from the pyre that consumed the Basel rooster, a community's fear of the unnatural made manifest in fire. You can hear the somber tolling of the Spanish church bell, condemned for its own negligence. This entire chapter of jurisprudence was so bizarre that it was largely forgotten by mainstream history for centuries, dismissed as a collection of unbelievable folk tales. It wasn't until the early 20th century that a scholar named E.P. Evans painstakingly gathered these stories from obscure court records and town archives into his foundational book, The Criminal Prosecution and Capital Punishment of Animals. He was, in a way, the first great historian of the absurd, rediscovering a world that his own rational age had tried its best to forget. And while the formal legal practice is long gone, the echoes of this mindset have never entirely vanished. You can still see a faint trace of it in certain folk rituals, like the Festival of the Cats in Ypres, Belgium, where, for centuries, cats were thrown from the town belfry to purge the town of evil spirits, a custom now reenacted thankfully with stuffed toys. The deep ancient impulse to identify a source of communal anxiety in an animal, and then ritually purge it, has a long and stubborn memory. And so the ultimate question that hangs in the quiet air, as the heavy oak doors of the past swing shut, is not just why they did it, but what it tells us about them. It reveals a world that, for all its brutality and what we see as irrationality, was also a world of profound moral conviction. Theirs was a moral universe that was wider than ours, one that held every part of creation, from the king on his throne to the beetle in the field, accountable to a single divine law. Their attempt to impose human justice on the animal kingdom was, perhaps, a strange and misguided expression of a deep and abiding belief that justice was not just a human invention, but a fundamental force of the cosmos. At the end of it all, you are left with a new and perhaps unsettling appreciation for our own legal system, which, for all its manifold flaws, has never, to my knowledge, had to issue a restraining order against a village's cats. The story is told. The courtroom is empty. And so the heavy doors of the past swing closed, the echoes of the courtroom fading into a deep and profound quiet. Let the weight of all that strange history, the images of the pigs and the pests and the solemn-faced judges, simply settle for a moment in your mind, like dust motes coming to rest in a still room, and now just as gently allow them all to drift away, becoming softer and less distinct with each breath you take. The flickering candlelight of the scriptorium becomes a soft, distant glow, and the rustling pages of ancient law books blend into the gentle hum of the world around you now. There are no more arguments to weigh, no more verdicts to consider. That world is very, very far away, and you are here, safe and comfortable, surrounded by a peaceful and welcome quiet. The story is done. The past is sleeping. Let your own thoughts slow now, letting them drift without destination, giving yourself over to the gentle pull of a deep and restful sleep. The journey is over. There is only stillness now, only peace.